Hi, I'm Michael Hughes, and this is Contract Mastery. In this video, we're going to talk about finalizing the lease agreement. We're going to talk about signatures to the lease agreement and delivery of the signed documents. So we've gone through and we've done all of our negotiation. We've done a little bit of back and forth. Everyone is in agreement. They've all seen a draft copy of the lease agreement, and now we're ready to sign. And here's where we're going to pick it up at this point. One thing to point out is if any of our parties are entity signers, if the landlord is perhaps an entity, or if the tenant is an entity, then refer back to our video on paragraph 1 of the lease agreement dealing with the parties, because we covered this in detail. But the bottom line is when we're dealing with an entity as a party to a contract, in order for that entity to sign, the entity cannot sign its own name. So what we need is a person, a human, who is going to sign their name on behalf of the entity. And then we're going to need that person's title that shows what their authority is to act on behalf of that entity. So if we had a corporation, it might be Jane Smith, president. If we had a trust, it might be Jane Smith, trustee. Or if we had an LLC, it might be Jane Smith, managing member or something. But you get the idea. We need the person's name and their title. What we do not want to see is a DocuSign signature that has the name of the LLC in scripty font on the signature line. That is improperly signed. An LLC or other kind of entity is fictitious. It cannot sign its own name. So we need the signature of a person who has authority to act on behalf of that entity. When we're getting the lease signed up, let's look on the left-hand side of the page for the landlord. If there is no property manager, then the landlord will sign the lease agreement. They'll either sign their own name if they're acting on behalf of themselves, or if it's an entity, then just what we were talking about earlier. But that is if there is no property manager. If there is a property manager, then we're going to jump down to the section below this bold-faced part here that says, or signed for the landlord under a written property management agreement or a power of attorney. If we are using a written property management agreement or power of attorney, so we have someone signing on behalf of the landlord, we will not have the landlord's signature on the lease, and that's fine. The landlord can appoint a property manager to act on their behalf. Now, mind you, back in paragraph 1, for parties, we're still going to have to write the landlord's name as the party to the lease agreement. The property manager is not a party to the lease agreement. They're merely acting on behalf of the landlord, who is the party to the lease agreement. So no landlord signature when we're dealing with a property manager. And then for getting the lease agreement signed by the management company, here are the things that we're going to see in these blanks. Where it says by, then we're going to need the signature of the person signing for the management company, along with a date. We're going to need the broker's associate's printed name. Notice this does not say broker associate. It says broker's associate's name. That means the agent's name. Whoever the associate agent is for that broker is going to sign their name right there. Then we're going to need, on the third line, the name of the broker, the printed name of the broker, and then below that, the name of the firm. So in the broker's printed name, What we're looking for there is the name of the designated broker of the management company. The designated broker of the management company. And then on the fourth line, we're going to write the name of the management company itself. And that's how we would sign for the landlord. For the tenant, then it's usually pretty straightforward. Most of the time, tenants are going to be acting as individuals. If you do encounter an entity as a tenant in a residential lease, that would be odd. But we would follow the same rules. They would have to have a person sign with an indication of what their title was so that we could get an idea of what their authority is to act on behalf of that entity. Once we get the lease signed, we have to deliver these signed documents, and the lease agreement form gives us a little boxed-in section here that says it's for landlord's use. And it says on whatever date, the landlord provided a copy of the lease signed by all parties to, and we write in the name of at least one tenant, because remember, delivery to one is delivery to all of them. And we delivered to that tenant by either mail, email, fax, or we handed it to them in person. And then there's a note here, a little reminder for the landlord. The landlord must provide at least one copy of the lease to at least one tenant no later than 3 business days after the lease is signed by each party to the lease. So the landlord has to give a copy of the signed lease to at least one tenant, and we write the name of that tenant in there and how that delivery was accomplished.